At this moment, I'm going to turn it over to Bethany Bridgham and let her talk to you about what her office does here at AU.
I've never needed a microphone before. I spent my high school and law school years as a lifeguard, so I'll try it, but if it's not necessary, I may drop it. The Office of General Counsel may be your only opportunity to get legal advice for free. We are on salary just like the rest of you. We don't bill by the hour. We don't bill by the matter. Call us up. We're always there. We're happy to chat with you. I often tell people that our office works like an emergency room. The first person you get on the phone is going to stop the bleeding, and then they're going to pass you off to an expert. So there are 5 attorneys in our office. We each have our own clients, as we refer to them, which relate to different departments and areas on the university. We probably cover somewhere between 40 and 50 different areas. My personal expertise happens to be in tax. I do all the transactional work for the university. Before Justin Perillo joined our office 12 years ago, I used to do all the IP and sponsored research work. We consider Justin the baby. He's only been with us for 12 years. The rest of us have been here for over 20. So you have a lot of institutional knowledge, and you have a lot of people who've been with the university a long, long time. And we cover everything from student grievances to the radio station to development work to tax-exempt bond financing, employee grievances, whatever you've got. So one of the resources that we can offer you as you're doing your research is we work very closely with the Office of Sponsored Programs. And if the Office of Sponsored Programs is reviewing your grant or the contract, they'll come to us and they'll say, hey, what do you think about this confidentiality provision? What do you think about this liability provision? How does that work with the university's insurance policies? The one thing you do need to remember, however, is that our primary client is the university as a corporation. And anything that you are doing within the scope of your employment for the university is covered, and you will be entitled to representation from our office. If, however, you are doing something outside the scope of your employment, you're running a lawn mowing business on the side and you run over somebody's dog. Okay, can't help you with that. But if you are acting within the scope of your employment, and let's say one of your graduate students is suddenly making allegations that he or she is actually entitled to the intellectual property that you have developed based on this grant, we would represent you in that instance. We also are available to answer questions about intellectual property in your classroom teachings. What might be fair use? We're here to negotiate your IP rights. We're here to assist with copyright and patent applications. We can defend against allegations of IP violations against you, and we prosecute AU's right to protect its intellectual property, including trademarks or any patents that we might hold. So the AU's policies on intellectual property are right on the Office of Sponsored Programs website. And if you go to the quick links on the website, the policies are right there. And AU's approach to copyright, there's nothing particularly exotic about it. We follow the same rule that a lot of colleges and universities do. Any scholarly, professional, and creative work by a faculty rests with the faculty member. The copyright rests with you, unless there's a written agreement that says otherwise, or there's been an exceptional use of university resources. So if the university has given you a ton of money or 16 graduate assistants in order to develop whatever it is that you're working on, the university might step in and say, well, we'd at least like a partial interest so that we could be reimbursed for the extraordinary resources that we've given you. But on a kind of a day-to-day basis, anything that you create that's subject to copyright belongs to you and not to us. Now that's for faculty. For staff, it actually belongs to the university. So when I created my remarks today and I hit save when I was developing this, as soon as I did that, it became an item that was subject to copyright. But because I'm a staff member working for the university and coming here to talk to you today is part of my job description, it's a work made for hire. And that belongs to the university. I have no claims to it. So the faculty do enjoy a different category than staff members, people who are hired as independent contractors, people who are hired on a limited basis. And you need to remember each time that you entered into one of these contracts, you need to check and look and see, what does that agreement say about the intellectual property rights? Does it say that I get them? Does it say that the university gets them? Does it say it belongs to the funder? The nice thing is, if you're working with the federal government, there's something known as the Bayh-Dole Act. And it says that even if you're accepting federal funding, anything that comes out of that research generally belongs to you, so long as you give the government a non-exclusive royalty-free license to use it. But again, you need to read the agreement, and that's where our office comes in, or where office-sponsored programs come in. They can help you read through those agreements and figure out where your rights are, where your rights exist. Now, the one caveat to that is, even though it does belong to you, the university generally does ask that we get, again, just like the federal government, a royalty-free, non-exclusive license to use it to further our own educational mission. On patents, we have a patent committee. It's made up of 5 members. Generally, 3 of them are faculty. And we look at patents as falling into 4 different categories. One would be something that you've invented all on your own. So that's known as inventions resulting from wholly personal research. And generally, that belongs solely to you. If you've created the best mousetrap in your garage at home, it belongs to you. University has no claim on it. The invention resulting from authorized consulting activities external to AU. As part of being a faculty member at AU, you are allowed to enter into these external consulting agreements. Generally, again, read the agreement. That will be governed by you, the faculty member, and whatever external company that you have entered into that agreement with. The third one would be inventions resulting from routine use of AU facilities and resources. So in your job as a faculty member, you're in your lab, you're kind of doing what you're supposed to be doing within the scope of your employment, and eureka, one beaker falls into the next, and you have just discovered the cure for the common cold. So in that instance, it was devised by you as part of your regular duties as a university employee. Again, generally, that still belongs to you. The university's policy is, you're the inventor, it still belongs to you. But if you request additional assistance from AU, so let's say you come to AU and say, you know what, I think I've found the cure for the common cold, and I'd like to take it out onto market. So we call the other Bethany, and we ask for her help in prosecuting that patent. The university is going to pay for those services, and in that instance, because you are asking for additional assistance from the university might say, you know, we'd like to be cut in on this, because you're asking for additional assistance. And then finally, inventions resulting from the use of special AU facilities and services. So let's say you think you can find the cure for the common cold, and you ask for the university for a complete course release for a full year. And you want to be in a lab with 5 graduate students doing nothing but this research. In that instance, again, there'll be a discussion between the university and you talking about how those rights to that invention ultimately will be split up. So you have what you think is the cure for the common cold. You send it to the patent committee. It's made up of 5 members. And they have generally 90 days to evaluate it. And if they figure out which bucket it's going to go into, and they'll write back to you and they'll say, congratulations, it's the first bucket, it's wholly personal, and it belongs only to you. If they don't get back to you within 90 days, then it's kind of like this you snooze, you lose rule, and so the university has no claim to it. If we don't get back to you in 90 days, then even if it's something where there was an extraordinary use of university resources, it belongs to you. So the impetus is on the committee to respond to your notice and get back to you and let you know where those ownership rights exist. So that's the university's role. Now, you have found the cure for the common cold. We believe that it's time to commercialize it, and then we pass it off to Bethany, which is exactly what I'm going to do.
Thank you. We made it very easy for you all so that everything in this section is by Bethany. So, all right. On mine, I have a nice little thing that I push easily, and it starts there. It is down there. All right, so my name's also Bethany. I'm with Tremonti Consulting. We are a consulting firm that works with universities and research institutions on the commercialization side of their intellectual property. So that's sort of the perspective that I'm coming from today. The first thing I want to talk about is technology transfer. I want everyone to think about that in a very broad sense. So technology does not have to mean I've come up with a new drug compound or a new widget. Technology in the sense of technology transfer can be much broader than that. It can be a new process or a new method, a new protocol, things like that. So essentially, if there's anything in your research that you're coming up with that you feel like there is a commercial use for, or something that there is a need for this in the marketplace, that is what technology transfer is. So don't think about it narrowly, think about it very broadly. These are the stages of technology transfer. So you're doing your research and you come up with something and you think, hey, this is really neat and there may be a good commercial application for this. If that's the case, then you file a technology disclosure form. And this disclosure form goes to John's office. It's available online. And you can fill that out and submit it to him. From there, a commercial evaluation is done. So as you can imagine, there is a lot of research that goes on at the university. There are a lot of great ideas that are generated at the university, but the university only has so much time and resources that they can commit. Not every idea, not everything that comes out of research is appropriate for commercialization. So there's kind of a two-prong test that the university has to look at. One, they have to say, is this even appropriate for commercialization? And then two, is this something that there's a significant market that would support this so that it makes sense that we choose this to be one of the things that we pursue commercially? After that, if the university decides, yes, we want to pursue this, then the task is to identify what type of intellectual property is most appropriate. There are some things that copyright protection is what's most appropriate. Some things it's patent protection that's most appropriate. And then the university works with their general counsel and their outside counsel to file for that specific protection. Once you do have protection in place, then we go to the marketing aspect of things, which is essentially we have this really great idea here and we're filed for protection for it, and now we want to market that to potential licensees so that a company in the marketplace can take it and run with it. Maybe it's that you think it would be great and you want to do a startup company around it, but most researchers want to stay with the research on the academic side. So then you can pass it off to a company and let them run with it and take it to market. From there, after you've marketed it and ideally you find a company that's interested, then you get to the last level there, which is the licensing or sponsored research agreement. So after we go through our marketing process, we kind of see this as a dual win. If you get a company that's interested and they want to move forward and license it and take your technology or innovation to market, that's great. But maybe it's not quite there yet, or maybe they would be interested in working with you and providing some sponsored research possibilities to get it to the next level or to see if it can do different things. You'll notice that these are in different colors, and essentially this is just to identify where my company, Tremonti Consulting, kind of comes in. So these areas that are blue, those are things that the university essentially takes care of. You're doing the research, the invention disclosure comes from you to the university, then they pass it off to Tremonti. Then again, the university is involved with the protection along with you, because that will require back and forth with you and getting your input to make sure that the appropriate information is being protected. And then the marketing and the licensing side of things are, again, things that Tremonti assists with. I will point out, much like the payment for the patent and for the copyright filing, the university covers that. The university also covers the cost of the marketing and for us to actually go out. So it's not going to cost you as a researcher anything extra to get involved in this process. So, when do you want to file an invention disclosure? Essentially what I say that you look for is what's the problem that I'm addressing? So, I'm doing my research and I've come up with this great breakthrough. Is there a commercial market for it? Is there something in the back of my head that says, I think this would be useful outside of academia? And that's when I think you should start thinking about technology transfer. Generally, I say to do this once you have something to support that this is going to work. I have an idea, and I have a good amount of data to say this is going to work or this is going to do what I anticipate it doing. And these don't have to be big ticket items. Most of the time in universities, these are going to be small improvements, small things that, that can be built upon. So it doesn't have to be, I came up with, again, a new drug compound, or I came up with this whole new machine to do this. It can be something small. It can be a new research reagent. It can be a new step in a process, a new process of way to do something. So again, once you realize that need in the marketplace, that's when you should file the invention disclosure. If you have any question at all as to whether or not you should file an invention disclosure, I would say defer to yes. And to talk to the office regularly and often. If you have any questions or concerns about, I'm not sure if this is right for commercialization, everyone is very willing to talk to you about it and see. There's nothing wrong with getting a no or getting it's a not ready yet. I say to do this early and often, preferably before you publish anything, because there are a lot of intellectual property rights that disappear as soon as you publish. So what we ask is that you let us know prior to publication what your idea is, and really the sooner the better, because that gives time for that 90-day window that the other Bethany was talking about, for the university to determine, is this ours, is it something that we want to pursue? And just also a little caveat at the bottom, any type of feedback that you get in regards to technology transfer is no merit on the scientific validity of what you're doing. So even if the university decides, you know, there's not a huge market for this isn't something that we want to pursue commercially, that in no way reflects on the scientific merit, because just because something is extremely interesting scientifically or socially doesn't necessarily mean that there's a commercial market to support it. So on the Tremonti side of things, whenever we get a new invention disclosure in, we want to help the university determine what does that market look like? What is this technology? So we look at this again from the commercial perspective, not from the scientific perspective. And that differs again from the legal perspective as well. So we're not saying you can get a patent on this or you can get a copyright on this. What we're kind of saying is, from a market perspective, there's an opportunity here, or there's not an opportunity here, or there's an opportunity here, but it's an extremely difficult path, and the likelihood of you getting through that is probably narrow. So the types of things that we look at in our commercial evaluations are, what's the relationship to a commercial application? Basically, what problem does this solve? So what issue is facing the market today, and how does this technology help that? We also break down the technology into a layperson's terms, so that the university, as much as we would like, does not have expertise in every single area, and certainly not to the detail that the researchers do. So this kind of breaks it down to a layperson's level so that they can understand really what you're presenting. And then we look at the competitive landscape and commercial benefits. So what's already out there on the market that's addressing this problem, and how is it deficient, and how does this technology improve upon that? Or does it at all? Maybe you've come up with a really interesting new way to do it, but it's not that much better than the current way out there, or maybe it's a lot more expensive than the current technique that's being used. Then we'll look at the market size and market trends. So overall, what type of market is this playing in? What's the size? Is it big? Is it small? Is it growing? Is it shrinking? Are people getting into this business? Are people getting out of this business? To give the university some perspective in terms of what type of opportunity is here. We also lay out the technical development in terms of, you're at point A, the technology itself needs to get to point B, C, D, E, and F before it's going to be actually ready to be on the market. So we can give an idea of what that looks like, what steps need to be taken. Some of those steps can be taken by the researcher themselves. Other steps, you're going to need a commercial partner to do that. And then, so at the end, we lay out who those commercial partners would be. So who would be the companies or the venture capitalists, the community and economic developers who could really push this technology forward. So from that, once it's decided, yes, there's a commercial market here, and this technology has a good opportunity, the university has filed for some sort of protection on it, then our job, Tremonti's job, is to help market that technology. So I use the analogy of fishing for technology marketing, and that will kind of play as a theme throughout. There are two different types of marketing. There's passive marketing, which is marketing that you'll do just by putting the technology out there. So that's just by publication. That's just by doing presentations, maybe posting it on a web page or different portals that are available for new technologies and that sort of thing. What we like to get more involved in is active marketing. So that's using a lot of different levels to actively go out and seek commercial partners. So the first one on their existing relationships has a lot to do with the researcher. When you're out and you're presenting, are you seeing companies, are they coming up to you and asking you for more information? Do you have an existing relationship with a company, something like that? So that's sort of on your end if you're going to be out to seek out those opportunities. Then there's also direct marketing, which we do, which is when we go and we actively seek out commercial partners for you. Again, we'll identify what those are. We'll put together marketing materials, which will look a bit like that in the right-hand corner, which will cover non-confidentially what the technology is, why it's good, what the applications are, what makes it attractive and important, and why the company should care. We'll also provide this list of companies and get your feedback, so if there's anyone that you've worked with in the past and you don't want to work with them again, or if there's someone that you feel like is missing and you think might be interested, we'll contact them as well. We also ask that you provide any additional non-confidential materials you have, maybe publications or presentations that you've done, so that we have those on hand when a company shows interest. So on our end, what we do is we actually pick up the phone and call these companies and get it to the appropriate person within the company to determine if they are interested in pursuing a commercial license or learning more about the technology. Again, we start off with that non-confidential document that we send them when we follow up with them via email. And then if they're interested, then we'll contact them with the university so that a non-disclosure agreement can be put in place and you can more freely share some information with them. And if anything's going to be sent physically, the university will also help you put an MTA in place. So, a few things to remember, and I'm going to try to wrap up because I know I'm running out on time. But the companies are going to be interested in the inventor as well, so it's very vital that you be involved in this process. So almost always the company is going to come back with some initial questions, or they're going to want to have a conference call, and we need the researcher to be involved in that process because no one knows the technology and what it can do as well as you do. So it's very important to have your expertise and to have your help. It may also be that this specific technology that you're working on or this specific area of research that you're working on may not be exactly what they're looking for, but they may ask you if you've ever considered going in these other directions, and that might be something that they're interested in. So if you're looking for potential other opportunities for funding, that's a good way to do that. And again, getting their input will help decide whether or not there is a true commercial value to the technology and whether the university may want to continue to pursue intellectual property. So if they go out there and nobody's really interested commercially at this time, they may decide not to continue moving forward with intellectual property protection. And that's just to kind of wrap up really briefly. Again, it's really important that the researchers be involved in the process. So if you only take away I'll say 3 things from this today. 1, think about technology transfer in a very broad sense in terms of what there may be a commercial market for. 2, to let John's office know about it as soon as you can, so then that way there's plenty of time to put all the pieces in place to make the commercialization pathway go smoother. And then C, I had my C, is that we need you involved. And that's through the entire process, marketing, protection. It really does require your input and your expertise. And I'll add a 4th, I guess. And that's just to feel free to contact us anytime with any questions. Again, Tremonti as a whole doesn't cost you anything individually or come out of your lab budget. It's a service that the university offers to you. So And I guess if that, on that note, if you have any questions for either Bethany, you can feel free to ask those. Yeah.
In this digital age, we have a lot of students, especially in the School of Communication, who are developing new innovative ideas, new apps, new games, things like that. So, I mean, I'm sure our game lab, for example, is already working with you on these kinds of things. But I was just wondering what the answer is to ownership rights of students working with faculty developing new technologies.
My first instinct is to say that something a student developed probably belongs to the student. I am not familiar with the, is it game, what'd you call it, game? Game Lab in SOC. I'm sure Justin, however, has been involved in it. He's out on paternity leave, so that's why I was kind of dragooned into doing this. So I'm sorry I can't be more specific. But as a general rule, like I said, when it comes to copyright, as soon as you hit that save button, right, whatever it is, once it's been fixed into a tangible medium, is subject to copyright protection. And if it's something that a student developed as part of their coursework, my argument would be that it probably belongs to the student.
I want to follow up, though.
Yeah.
You know, it's very related to this. For example, we have a new science building coming up soon, and there's a plan
Now, that's
to have,
something I am working on.
Yeah, and there's a plan to have this maker space where
Okay.
students could create and experiment and do things like that. But there's going to be staff and faculty that they're going to be interacting with. And the reality is probably there's going to be some real insights and help that are coming from staff and faculty. The students aren't just going to 100% create something. So it seems like it could be very complicated, and we're wondering how we're going to
Right,
deal
so
with students.
that would go back to what the other Bethany said, get us involved early and often. And reach out to our office and say, okay, you know, we're coming up with this, and there's some gray areas here. Because it's going to be the university staff, university faculty working with students, and we want to make sure that the IP rights are allocated accordingly. And that might be a situation where you have joint ownership, because everybody's contributing. And again, this goes back to one of the things that we often try to do when we get agreements from external third parties, is that even if you don't get, say, ownership of the IP rights, we want to make sure that we can use it for purposes that are in keeping with our tax-exempt mission. Research, archives, talking about scholarly activities on campus. You should be able to present it at conferences. You should be able to reference it in your CV. And so we might not get ownership, but we're certainly going to expand the amount of rights that you have to kind of exercise an opportunity for something that you've created.
This is just a similar follow-up, but are there any templates for that, or are we just starting to emerge? It would be great to, like, I have a bunch of these things that merge a bunch of different people. It'd be great just to say, this is our general approach, and if we have a big project or a grant, or it's really, but there's like, I can point to like 5 different ones.
Right. So our office on a regular basis creates non-disclosure agreements that are tweaked for the specifics. We do templates for this kind of joint ownership of copyright. I don't know how many of you know this, but the Claude statue that's out in front of the gym, okay, there was an instance where we were paying the artist to create the statute, but he actually wanted to retain his IP rights. And so we got into a little back and forth about, no, we're paying for the statute, and we want the whole bundle. So I won't necessarily say that there's a template, but we have done this many times before, so it won't take us that long to put something together that's specific to your needs. Okay?
Yes, I wonder about software production in general. I ran into a problem before because it was a program not even, we copyrighted it, but not for commercial purposes. And then I wanted to use my own grant, and there was some sort of copyright conflict between a research institute and my employer. And to my surprise, it seemed that my program is not my program. So that is something I would be interested to know. If I produce software, does my employer own it, or do I own it?
Okay, first question, are you faculty or staff? You're faculty, okay. So I would suggest you need to go back and look at the agreement, because if you sign an agreement that says anything I produce with this grant money belongs to the person who's providing the grant, then that supersedes anything that our policy might say. And then you're talking about software, and so my next question would be, was it software you created from scratch, or was it a derivative work? Because if it's from scratch, okay. I mean, if it's a derivative work, copyright holders are the ones who are entitled to derivative works from their original invention. So, I mean, your question sounds like there's a lot of kind of nitty-gritty that probably we should talk one-on-one.